Hearing in the appeal FMX Food Merchants against Commissioners for Her Majesty's Revenue and Customs.
Yes, sir.
My lords and my lady, I appear with my learned junior, Mr. Pritchard, for the appellants, and my learned friends, Mr. Cavender QC and Ms. Sloan QC, appear for the respondent taxpayer, FMX. May I begin by expressing our sadness at the untimely death of Mr. Justice Henry Carr after the delivery of the judgment against which this appeal is brought. After a short piece of housekeeping, I propose to address our grounds of appeal in order, 1 to 4. That short piece of housekeeping relates to two particular matters. Firstly, I hope that the court has received an update on some page references in the cases that went astray. And secondly, your lordships and your ladyship will have before you a better version of one of the judgments in a case called Gilbert's Noir.
Yes.
Now has paragraph numbers, whereas regrettably, the one in the
I don't seem to have received these documents, but I will be able to catch up at lunchtime.
I'm very sorry, my lady. We'll make sure that is rectified. Turning then, if I may, to ground 1. Ground 1 essentially concerns a question of statutory construction of Article 2213 and subparagraph 4 of the Customs Code. It's addressed in our case at paragraphs 44 to 56. That's electronic bundle, page 80. I don't apprehend that there's any dispute between the parties as to the principles governing the construction of EU law. They're well known. So one looks at the ordinary and natural meaning of the words. One has to take into account the legislative context. And then also it's necessary to consider the purpose behind the legislation. Please could I start then by looking at the relevant provisions of the Customs Code to show their context. That's in Primary Authorities Bundle, tab 3, starting at page 419 of the electronic bundle. Pick it up, please, at Recital 8, which is at Electronic Bundle 420. Recital 8 confirms that one of the aims of this particular measure is to ensure that the utmost care is taken to prevent any fraud or irregularity liable to affect adversely the general budget of the European communities. That's the last recital on that page, just before the general provisions start at Title 1. So it's the last paragraph in the preamble. That helps explain one of the purposes behind the code. If your lordships and your ladyship would then be kind enough, please, to look at the definitions, which begin at page 421 of the bundle, bottom of the page, Article 4, sets out a series of definitions. And then turning over the page to 423, if I could just highlight one or two en passant. Page 423, recital, subparagraph 9, defines customs debt as the obligation on a person to pay the amount of the import duties, or customs debt on importation or export duties. Here, we're dealing solely with import duties. There's then a definition given to import duties in the next paragraph. And debtor in subparagraph 12 is defined as any person liable for payment of a customs debt. Turning over the page 424, you see a variety of different customs procedures are defined. Here, the relevant procedure that was adopted by the Customs Declaration was release for free circulation. So the goods are cleared through customs, the customs duty is paid, they're then treated effectively as goods within the EU and are capable of being moved, having been paid. Customs Declaration under subparagraph 17 means the act whereby a person indicates in the prescribed form and manner a wish to place goods under a given customs procedure. So here, FMX, as the declarant on a customs declaration on a series of consignments, said that they were clearing the goods as frozen garlic and entering the duty accordingly, and the goods were released for free circulation. Declarant was defined as the person making the declaration, either in his own name or the person in whose name a customs declaration is made. That is relevant where typically a customs agent is used to interface with the chief system, which is the computer system that HMRC operates for imports. Finally, on the definition section, subparagraph 23 says that provisions in force means community or national provisions, and that assumes some importance when construing the terms of Article 2213 and 4 shortly. The structure of the Community Customs Code, then, is that a customs debt, see Article 201 at page 425, is incurred through the release of the goods liable to import duties. So once they're cleared using the customs declaration procedure, they're entered for free circulation, the import duties fall due, they're then released for free circulation. Customs debt arises at that point. It's incurred at the time of the acceptance of the customs declaration in question. See Article 201, subparagraph 2. What then happens is dealt with at Article 217, electronic bundle, page 426. The UK as a member state is obliged to enter in the accounts the amount of duty that's due. So it's calculated by HMRC based on the tariff that applies to the particular goods. There's then an entry made in the EU accounts, and in due course, through a separate process, the amount of duty that's due is accounted for to the EU itself, because the customs duty forms part of what are called EU own resources, and therefore it's a direct budgetary hit, as it were, in favour of the EU, as and when the goods are brought in. The United Kingdom, in common with other states, takes a percentage chunk as an administration fee, but the bulk of the debt is then due to the community as own resources. Article 218 confirms that under subparagraph 3, where a customs debt is incurred under conditions other than those referred to in paragraph 1, the relevant amount of the duty shall be entered in the accounts within 2 days of the date on which the customs authority are in a position to calculate the amount of duty in question and determine the debtor. Now, subparagraph 1 simply deals with a position where the goods are entered for result of an acceptance of declaration of goods for a customs procedure other than temporary importation, entered in the goods as soon as it's been calculated or at the latest second day following. So there's a general imperative to enter the debt in the accounts in a very short space of time. It can be subject to an extension in appropriate circumstances. But generally, it's considered to be something that's done pretty speedily once the customs debt is incurred. Now, if in fact the original declaration is not correct, then Article 220 sets out some quite detailed provisions that deal with the circumstances in which the customs debt can be amended. The general obligation under subparagraph 1 is that where an incorrect declaration is discovered, and therefore the incorrect amount of the duty has been accounted for, you have to enter the correct amount in the accounts. Would the court please be kind enough to read the rest of Article 220, subparagraph 2, because it deals with circumstances in which the debt may be waived or remitted if certain criteria are met.
Could I just invite you to take a little longer over this so that I can be quite sure that I've understood the legislation? If am I right in understanding that the debt is incurred, the debt arises and is incurred even in the event, for example, that a declaration is inaccurate, either accidentally or deliberately, the debt is nevertheless incurred despite the fact that the customs authorities are unable to calculate how much it actually is. Is that right?
So the original customs debt will be the amount that the goods are entered for. In this type of case where, for example, you have an OLAF mission report that shows that there was a fraud operating in the markets, several years after the original customs declarations are made, the obligation under 220 subparagraph 1 is to correct the accounts, to amend the accounts to reflect the difference in customs duty that is due. And
Yes.
so the decision that's then taken is to rectify the missing duty and enter that as a separate amount in the accounts as soon as you've been able to calculate exactly what it is. So you have the original debt and then you have the extra bit. And
Yes.
it's the extra bit that's then entered subsequently.
So at what point in time is the debt actually incurred in relation to the additional bit?
The debt will be due, curiously, under Article 201, the debt is due at the date of the declaration. So the debt technically arises at that point. But
that's the true debt, regardless of what may have been recorded in the accounts.
Yes.
Yes.
And the post-clearance entry in the accounts then makes up for the shortfall in the accounts as an accounting mechanism between us and the EU. We then have to notify that true debt, as it were, by way of a communication to the debtor in the manner that I'll come on to.
Yes, and one sees that in 201 paragraph 3, the first sentence is expressly envisaging a situation where a declaration is drawn up on the basis of information which leads to duties legally owed not being collected.
Yes.
Yeah.
So I skipped over that bit, I'm afraid.
No.
But, Your Lordship's absolutely right that makes clear that essentially where there's something missing in the declaration, it's still the original declaration that characterises the creation of the debt, but the amount of the debt that's due has to be rectified.
Yes.
And really, Article 222 then establishes a form of balance or allocation of responsibility between the taxpayer, the importer, the declarant, and various different authorities. One of those authorities will be the authorities of the customs body that is in the country of importation. Another will be the customs authorities that are operating in the third country. And this particular provision was put in place with effect from, I think, sometime in 2000. The idea behind it is that the risks of fraud by exporters shall not be laid at the door of the EU if, in fact, there is an incorrect export certificate in circumstances where that export certificate has arisen as a result of incorrect information being provided to the exporting authority. Generally, if, for example, a third country produces a wrong certificate and it's their fault, then the trader is able to rely upon Article 222 and the customs debt will be remitted. If, however, the customs debt has only arisen and because of an export certificate that's wrong because of false information fed into the exporting authority, then the trader cannot rely upon that circumstance to remit the debt.
Yes.
There's a division of responsibility as to who is going to shoulder the burden of the fraud.
Yes.
And of course, if a trader is able to establish that they've acted without deception or obvious negligence, and it's not the exporter's fault that the certificate was wrong, then they will have their customs debt waived. That debt will then not therefore be due regardless of what the limitation period may or may not be.
In a situation where where the customs authorities aren't in a position to calculate accurately the amount of duty due at the time when the debt is incurred, then they're required by 2183 to calculate the amount and enter it and they have to enter it into the accounts within 2 days of the date on which they become able to do so.
Yes.
Yeah.
So that's the additional bit, as and when you can do that. It's then entered in the accounts.
Yes, and that in principle could be years later.
Yes.
Yeah.
Article 221, subparagraph 1, then is the final piece in the jigsaw in terms of this additional bit, and it says as soon as it has been entered in the accounts, the amount of duty shall be communicated to the debtor in accordance with appropriate procedures. So ordinarily, if, for example, you're declaring for free circulation and the commissioners are happy with the declaration, then the goods simply come through the debt paid, and that's the debt earned. Where you have an additional bit as a result of facts that come to your attention, perhaps years later, as my lord indicated, then you have to communicate the additional debt, and it's that additional debt that is then communicated to the debtor.
Yes, and in 2211, we see that one time constraint is that the amount has to be communicated as soon as it's been entered in the accounts.
Yes.
Yeah. And you're no doubt about to bring us to paragraph 3.
So three and 4, I'm sure the court is now wearily familiar with, but let's, if we may, just look at them. So 3 and 4 represent the bifurcation of the provisions of what was formerly the Customs Code with effect from 2000. So the relevant paragraph previously was in one paragraph, subparagraph 3. It's then split out with effect from 2000 so that you have 2 separate limbs to it. The first provision under subparagraph 3 is communication to the debtor shall not take place after the expiry of 3 years from the date on which the customs debt was incurred.
So just say, for example, the customs debt is incurred, 4 years pass, and it's then discovered that there had been, as a result of some innocent misunderstanding, mistake, an error in the declaration. At that point, there's nothing that can be done about it. Is that right?
That is right, because you wouldn't be able to do anything other than establish the customs debt on the basis of the original declaration.
Yeah.
And being able to do anything with the declaration would also depend on the application of that same period in the light of the fellow service.
Yeah, that's it. Thank you.
Now, obviously, that period is then suspended to allow appeal proceedings to take place. In contrast, subparagraph 4 then critically says, where the customs debt is the result of an act which, at the time it was committed, was liable to give rise to criminal proceedings, just pausing there, those criteria are met here. It wasn't seriously challenged, actually, at first instance before the first-tier tribunal. Those criteria were met in the fact of this case. The amount may, under the conditions set out in the provisions in force, be communicated to the debtor after the expiry of the 3-year period referred to in paragraph 3. So the key issue in this case, in many ways, is, starting at least, does that represent what is described by the Court of Appeal as an extension of the limitation period in subparagraph 3, or does it, as in our submission, simply leave to the member states the decision as to the nature and means of the communication to the debtor after the expiry period? And the effect of subparagraph 4 is that if, as a matter of fact, the customs debt is the result of an act which at the time it was committed was, in inverted commas, criminal, close inverted commas, then that disapplies what would otherwise be a 3-year limitation period.
But it may be the result of criminal conduct which is not the conduct of the person liable for the debt.
That's absolutely right. The case law of the CJU establishes that the ultimate debtor doesn't have to be the person who has been guilty of the criminal conduct.
Yeah.
It's designed, as I'll come on to show by reference to the Snow Ark case, it's designed to enable deficiencies in the entry in the accounts to be rectified by the commissioners in circumstances, or National Customs Authority, in circumstances where it may be some time before, for example, a fraud is uncovered. Typically, these cases involve international missions from the European Fraud Office, OLAF. Sometimes takes many years for the relevant permissions to be put in place before a trade mission can be take place in, for the sake of argument, Cambodia in this case. And the true facts of the fraud don't come to light until many years later. That then is Article 221. For the sake of completeness, I should also point out under Article 236, duties shall be repaid or remitted, as the case may be, in circumstances where the criteria under Article 222 are met. Now, the difference between repaid and remitted is either the duties already being paid by the trader or standing on account and not actually yet being paid, at which point it would be remitted. But either way, if you meet the criteria for Article 222, namely absence of deception or obvious negligence, then absent other matters such as the fraud practiced on the export authority who has produced the certificate, then you can have the entire customs debt waived. Why is that relevant? Well, I don't wish to turn on the light in the jury box, but my friends have tried to suggest that this particular scheme is capable of capturing what they describe as innocent traders. Strictly speaking, it doesn't. Because if somebody has acted without deception or obvious negligence, they are prima facie entitled to establish remittal or waiver of the customs debt. The only exception would be if they had benefited from an export certificate produced by an exporting third country that was procured as a result of false information provided to the exporting. And that's a specific provision that's been put into Article 220 with effect from the year 2000 to deal precisely with the problem of many export certificates being produced through fraud, tendered to the EU authorities across the entire EU, and there being no recourse otherwise for the EU budget. The European Union in this legislation that drew up the allocation of responsibility between the member states and their budgets and individual traders, and said that individual traders had a responsibility to make sure that they took adequate steps to protect themselves against fraud committed by exporters. That's all dealt with in the first instance decision of the FTT, which your lordships and your ladyship will find in the electronic bundle at page 444. I'm not going to dwell on it because the Court of Appeal made the perfect sensible point that this is a legal construction issue. Whether or not the FMX is good, bad or ugly is in a sense irrelevant to the question of whether or not limitation applies. So with that interjection, I'll turn off the light in the jury box and move on to the question of what the structure shows.
And can I just ask, the cases rather focus on paragraphs 3 and 4, and that paragraph 1 is also important. It imposes an obligation to communicate the amount of duty as soon as it's been entered in the accounts. And we know that there is, behind that, the duty in 218 to enter it in the accounts as soon as you're in a position to do that. So,
what your lordship doesn't have is a case called Coverter,
right,
which deals with what happens if you don't enter the sum in the accounts in the required time.
Yep.
Answer, it doesn't give you a right to set aside the customs debt. It's simply an internal matter between the UK and the EU.
That would be quite useful. Because I was wondering if paragraph 3 might be, as it were, a rule that didn't detract from the obligation imposed by 1, but it sounds as though it's only 3 that is designed to protect for the protection of the debtor.
Yes, the protection of the debtor takes the form of the general 3-year limitation period in 2213, and such protections as are conferred by domestic law, which is as a result of where it's a specific subcategory of a criminal act.
Right.
And you then default under the competences of the EU at the time. It's changed now, I'll come on to that in a moment. At the time, there was a division of responsibility between the EU and between the member states, where competence for criminal matters was effectively left with the member states, and you default to the member states.
Well, it'd be helpful if at some point we could be given a reference to that authority. Of course. Yeah, thank you.
That, therefore, is the structure of the legislative provisions, and in essence, the UK here was duty-bound to amend the accounts and account for the correct duty once it had established that FMX had wrongly entered the goods as Cambodian garlic. The only basis for not entering in the accounts would be if we weren't able to communicate the debt to the debtor because of the expiry of the 3-year period. That 3-year period here does not preclude post-clearance entry in the accounts because the imports in question were the result of an act which was liable to give rise to criminal proceedings. That's dealt with the context. Could I then please turn to the purpose behind the measures? Clearly, the UK has a duty of sincere cooperation to the EU. It's a general requirement that we should try and get in EU-owned resources if we can. I think it's well known that the UK is occasionally subject to infraction proceedings to repay customs debt if it hasn't done everything it can to get them in. There's a large case going on at the moment. But the purpose behind the provisions is therefore to ensure that underpaid customs duty is in fact paid. Otherwise, the EU-owned resources would be constrained, and in essence, there would be a preference for unscrupulous exporters to be given latitude over and above the requirement to get in money in the budget. That purpose can be established in one particular case. There are more, but I'll deal with the proposition simply from one, if I may. That, in fact, is the case I've passed up as a standalone document with the Gilbert-Snowott case. For your reference, that's in electronic bundle, page 1392, which is in the supplemental volume. The version I've passed up has paragraph numbers in it. The purpose is identified at paragraph 26 of that decision.
I'm sorry, could you just give me the electronic page again?
Well, my reference is 1392. I'm hoping that's right.
Yes.
Thank you.
My understanding is that don't have it immediately to hand, but that doesn't have the paragraph numbers in it. One sees at paragraph 26 the overall purpose behind these particular provisions. Please, could you read paragraph 26?
It's the paragraph starting, the court also has also had occasion.
Yes, thank you.
Down the page, if you're looking at it electronically.
Not on 1392, it's not. I'm very grateful to my lord.
Tab 46.
Hang on, my lord's shown me where it is.
1392 in the middle of the page, there's a paragraph that begins.
First of all,
The court
thank you.
also had occasion.
First of all, paragraph 25, the next one.
Yeah. Thank you.
Sorry, it was very difficult to read, which is why we passed up the additional copy.
Thank you. Yeah.
Thank you.
Then in 30, which my lady will find, the paragraph that begins consequently,
Thank you.
second as an exception, and then consequently, I'll read it, perhaps it's easier. Consequently, it's apparent both from the wording and the broad logic of Article 221 of the Customs Code that the amount of duty may be communicated to the debtor after the expiry of the 3-year period, where, as a result of an act that could give rise to criminal court proceedings, customs authorities were initially unable to determine the exact amount of the duty legally due. That includes cases where the debtor is not the person who ultimately committed the act. That interpretation, paragraph 31, that interpretation is also borne out by the use of the words such communication in the second sentence of Article 2213, which refer back to the words communication to the debtor in the first sentence of that provision. Thus, Article 2213 does not confine the communication of the duty due to cases where the debtor ultimately committed the act that could give rise to criminal court proceedings. That establishes, we say, that the purpose is to, per paragraph 26, it's an administrative procedure to make sure that you've made good, incorrect, or insufficient collections of import duties. I should also point out for completeness in paragraph 29 that Article 2214, as it is now, is described as an exception to the basic 3-year limitation period. So in terms of moving on to the construction of Article 2214, we've identified 2 particular cases that help elucidate its purpose and its overall construction. With respect to the Court of Appeal's judgment below, we say that this particular provision does not spell out a positive obligation on the UK to put in place a limitation period. That can't be spelled out from the reference to conditions set out in the provisions in force, because it's the communication of the debt that is governed by the conditions set out in the provisions in force. But no particular provisions are stipulated, either in the legislation or, as we shall see, as a result of the court's case law. The first of those cases is Agra SRL. That can be found in Primary Authorities, tab 7, Electronic Bundle, page 542. Is the first page of the judgment. Could we pick it up, please, at paragraph 6, which is page 547. The relevant provision of the domestic law provided that the substantive right of the state to recover customs duties shall be extinguished on expiry of a period of 5 years, where the failure to pay customs duty has its origins in whole or in part in a criminal offence. Time for the purposes of the limitation period shall run from the date on which the order or judgment in the criminal proceedings becomes final. So Italian law applied a general recovery limitation period of 5 years, notwithstanding the requirement of 3 years in the Customs Code. Then specifically for what I might describe as a criminal act case, then time would not run until the date on which the order or judgment in the criminal proceedings became final. Of course, it follows from that if you never have criminal proceedings, or indeed they never become subject to an order or judgment that is final, you have an indefinite period of application of a limitation. Relevant facts are set out at paragraphs 8 through to 11. Please would the court be kind enough to read those facts. So 8 through to 11, page 548. Applications were in 2002. What then happened was paragraph 13, a reassessment notice was served on the 11th of March 2008. That was outside the primary 5-year limitation period. One of the issues referred was circumstances in which you could invoke what is now Article 2214. Paragraph 28 and 29, page 552, the court did its classic thing of recharacterising the referred questions and identifying what the issue was. So 28, it said, it's apparent from the order for reference that the National Court is inquiring as to the consistency with EU law of legislation, which provides that where the failure to pay customs duty stems from a criminal offence, time for the purposes of the limitation period is run from the date on which the order or judgment in the proceedings becomes final. Paragraph 29, from that point of view, it must be held that the referring court is essentially inquiring whether Articles 2213 and 4 of the Customs Code preclude national legislation such as that in issue of the main proceedings, under which where the failure to pay customs duty has its origins in a criminal offence, time for the purpose of the limitation period is what is then a reference back to domestic legislation. Please would you then read paragraphs 32 to 35, which set out the court's answer to that particular issue. Summarise the structure there. Paragraph 33 essentially says there's no limitation period to be applied as a result of Article 2214. 34 says the conditions set out in the provisions of force effectively defer to national law as to the rules interposed there, if any, regards the rules governing the extinction of the customs debt. And then 35 says essentially it's a question of competence, and the EU hasn't exercised competence for this. It's for the member state to determine the appropriate rules.
Can I ask, Mr. Beale, one of the arguments against you founds on the words the conditions set out. Now, those words weren't part of this provision in its earlier form when it was the second sentence of 2213. At that time, it was insofar as national law allows. And that particular argument would have been more difficult to advance. Is there any information about why the change in wording occurred?
The recitals in the relevant regulation from 2000, we don't have before the court, but I had a look at them, and it's not apparent from that why they decided to break out what was previously paragraph 3 and make it 2 separate paragraphs.
Yeah.
They did also change the wording in a different way, which is to remove the requirement, for example, for that procedure only to be used where the customs authorities hadn't been able to determine the amount due.
Yes.
So that was removed, but this was put in place.
Right.
Conditions in our respectful submission on the ordinary and natural meaning of the words tie into the act of communication.
Yes, I understand that. That's the argument.
They don't connote a substantive obligation to impose a limitation period. 35, in a sense, confirms that, because it says, well, it's not for the EU to get involved in that. You defer to the rules governing extinction through the passage of time of customs debts under the national regime. Next case is the Molen-Bergonesi case, which is in Primary Authorities tab 11, electronic page 681. Now this case, as we can see from paragraph 17, at page 690, electronic bundle, concerned the importation of video cassettes into Belgium from Macau, from Hong Kong. There was a generalised system of tariff preferences for goods originating in developing countries, so that they were exonerated from customs duties. Following an investigation, it transpired that the origin had been wrongly declared. They were actually Chinese rather than from Macau, and therefore they didn't benefit from the GSP preference regime. The customs authorities in question, let's see paragraph 20, informed the agent about the investigation and notified him of the amounts of import and anti-dumping duties due. The amounts were then entered in the accounts, 7th of March, but the formal communication of the debt didn't take place until September 1995. So, notwithstanding the original notification that was pre-entry in the accounts, the court holds that didn't have any effect because you need the entry in the accounts first. So the formal notification is September 1995, which is beyond the 3-year time period. Starting from April 1992, for at least some of the consignments. So in essence, the entry in the accounts was within 3 years, but the communication was outside 3 years. Paragraph 39 and 41 sees at page 697 of the electronic bundle, the court recognising it's beyond question that the expiry of the 3-year period in 2213 of the Customs Code was a bar on the right of those authorities to recover the debt, unless it's as a result of an act that could give rise to criminal proceedings, that the customs authorities were unable to determine the exact amount legally due. However, the provision at issue at the same time enacts a rule governing the customs debt itself and thus establishes a rule-long limitation in respect of the debt. Under paragraph 41, it said it must therefore be held on the expiry of the period prescribed by Article 2213, the debt is time-barred and extinguished, and that's a substantive rule. Because it was a substantive rule, it meant that it could only take effect from essentially the date on which the measure entered into force. So that's determining which particular variant of the customs code applied. At 50, the court moved on to the fourth question, which is the relevant one here. And the fourth question was identified as whether member states are required to determine the procedures in accordance with which notification of the amounts of duties under 221 must be made to the person liable for the debt. The court's answer to that was set out in 3 paragraphs from 52 through to 54. Please can I invite your lordships and your ladyship to read those paragraphs. So that's 52 through to 54. court there is recognising that essentially it's for the legislation of the member state to determine the mode and method of communication of the customs debt. You don't need specific rules to be in place. You can defer to the general rules, domestic law of the member state, in order to achieve that process. What matters is that the debtor should be informed of the customs debt and be put in a position to establish his rights.
Article 52, I don't imagine you dispute, indicates that the member states have to do so in accordance with general principles of community law. No.
No, I mean, in fact, we obviously pray and aid the fact that we are obliged to act in accordance with the principle of legal certainty as part and parcel of our response to the suggestion that we could prosecute stale claims.
Yeah.
There is one further case in the additional authorities bundle, volume 2, tab 53, electronic bundle, page 1639, that deals with, if I can put it this way, the absence of an obligation to put in place domestic law as a result of a core EU duty in this particular field. That's the Remo Padovani case. That's tab 53 of the additional bundle. Starts at page 1639. In that particular case, there was a change of construction of some relevant legislation. Everyone had been going along merrily, thinking that one particular interpretation applied. The CJU, in a judgment called Fracassetti, see page 1641, paragraph 4, changed that construction, and therefore, because it operated without temporal limitation, it operated to change the customs declaration, import declarations for goods prior to that particular judgment date. The question was whether or not, if Italian law, as it didn't provide for example, the protection of legitimate expectations, whether or not EU law would require it essentially to put in place a framework of domestic law in order to make good that deficiency. At paragraph 19, page 1644, the court held that it was apparent from a comparative examination of the relevant provisions of national law that it's not possible to identify principles common to the laws of the member states or generally recognised by those laws from which a general principle of community law requiring national authorities to refrain from rectifying insufficient payment of community levies after the expiry of a uniform period of time or in the event of an error attributable to the national authorities could be deduced. So there was no common approach to limitation between the member states. They then said, paragraph 20, in those circumstances it couldn't be considered that restrictions which Regulation 1697-79 placed on the post-clearance recovery by national authorities could reflect an underlying community principle of protection of legitimate expectations. What had happened in this case was that after the date of the events in question, EU legislation was put in place which effectively now reflects what is Article 220. So you have waiver of the customs debt if you've acted without obvious negligence or deception, and that protects the legitimate expectation of a trader who's complied with those principles. That, however, wasn't available to this trader because the EU legislation didn't apply. What the court found, however, at paragraph 24, is that providing you comply with the principle of equivalence, it's for national provision solely to determine the recovery of customs debts. And then paragraph 25, should the national law applicable as regards the details, ruled and conditions for recovery not contain a principle of protection of legitimate expectations, community law does not preclude the application of national law in that form, provided it was comparable and purely national debts are not governed by a different principle. So in other words, there is no obligation under EU law to put in place, in that case, a recognition of a principle of legitimate expectation, simply because it's for national procedure to determine. You have your national procedures in place. As long as they comply with principles of equivalence and effectiveness, they govern the recovery of the customs debt in question. Now, what that means, we say, is that there is no obligation as a result of Article 2214 for the UK to put in place a limitation period. The question of whether or not the UK has a limitation period is a matter for domestic law, subject to compliance with general principles of EU law more generally. Of course, you can have a situation where there is a requirement for a domestic limitation period to be put in place. One such example of that can be found in the Financial Irregularities Regulation. That's in Additional Authorities tab 22, electronic bundle page 812. So that's the first bundle of Additional Authorities, tab 22. This is the regulation that is cited in Zayfu, Fleischhandel, and other cases. But if I invite you please to turn to page 813, this is a regulation that governs irregular procedures in EU legislation more generally, not specifically the Customs Code. Article 3.1, page 813, says the limitation period for proceedings shall be 4 years as from the time when the irregularity referred to in Article 1 was committed. Sectoral rules can apply. And then in particular, under subparagraph 3, the bottom right-hand column of that page, member states shall retain the possibility of applying a period which is longer than that provided for in paragraphs 1 and 2, respectively. So that's EU legislation saying you get 4 years, subject to the sectoral issue, you get 4 years unless you, the member state, retain the possibility of applying a different period. So if you're going to comply with that and get away from the default period of 4 years, you have to positively put in place legislation to get access to a different limitation period. And a similar structure is now adopted under the Uniform Customs Code, which your lordships will have seen. Article 103, it's referred to, I think, in both cases. Article 103 says you can have a longer period between 5 and 10 years if you adopt it under your national legislation. So that is another example of EU legislation actually requiring you to put in place a different limitation period if you are to opt out of the default provision. We say in contrast, Article 2214 doesn't do that. It simply says, as a matter of competence, you, the member states, are responsible for setting the limitation period, and your lordships and your lordship have seen that Parliament has done that in the Limitation Act, section 37(2)(a), by setting no period of limitation under the General Limitation Statute for recovery of customs. Now, we say since EU legislation does not impose a requirement to set a limitation period, and seeing as one isn't found as a result of Parliament's intervention in our domestic legislation, any requirement to have a limitation period in place must necessarily be found elsewhere. And so I now turn to ground 2, which concerns general principles of EU law. And the issue here, having dealt with, I hope, the question of statutory construction, is there anything in the statute that requires this? Answer, no. Is there anything in the general principles of EU law that requires the EU to set a limitation period? My answer there would be no, there's nothing to require a specific limitation period. What EU law does do, however, is provide protection to taxpayers so that they don't face stale claims or have an obligation to the state occurring many years after the event. So, ground 2 is addressed at, if you'll note, at paragraphs 57 to 68 of our case. And of course, we've recognised, as indicated to my Lord Reid, general principles of EU law encompass protection against stale claims. For example, Article 47 of the Charter, what I'll come on to identify as an obligation to act within a reasonable period of time. All of those things operate as a matter of general principles of EU law. None of those things can dictate to a member state that you must have in place a specific limitation period. Some positive obligation. Those principles will be used as a shield rather than a sword. So they operate to the benefit of an individual trader in certain circumstances, but it doesn't provide a systemic response to the absence of a limitation period in this case. Now, of course, if my learned friend's argument were right, there are some, if I may say so, slightly dramatic consequences for domestic law. So, for example, the doctrine of late cheese would have to go out the window because it wouldn't, in their case, be sufficiently specified in advance as to when it operated as a matter of equitable principle. And this court's decision in the Burnden Holdings case, which dealt with Section 21 of the Limitation Act and express trustees and fraud and application by analogy to company directors. That, of course, doesn't establish a limitation period either for, in those particular circumstances, breach of trust through fraud. You default to a late cheese position, and by parity of reasoning, you'll end up with potential EU law challenges to that whole suite of limitation provisions. Now, we say there are two clear cases where the CJEU has made it clear that legal certainty does not impose a specific requirement to enact limitation period. They're both state aid cases. Why are they state aid cases? Well, because for many years, the state aid rules had no limitation period. That changed in 1999, but before that, the Commission was able to start recovery actions against member states and require beneficiaries of state aid to pay back the state aid without any limitation being imposed upon recovery. The first of those is in Primary Authorities, tab 9, electronic bundle, page 571. It's the Breda-Fucini Meridionale case. It's 571. The relevant facts can be found at paragraph 15. The Commission adopted a decision, that's page 577, electronic bundle. The Commission adopted a decision concerning certain measures granted by Italy in favour of BFM. In short, at page 578, a whole suite of objections were taken to subsidies given to a particular business. Paragraph 17, as is common, the state aid decision required Italy to recover the aid and to do so forthwith and suspend the application of provisions relating to the extension of the derogation, etc. So it had to recover the subsidies that it had granted. Paragraph 61, page 590, the electronic bundle. The applicants argued that by extending its review after 1995 to acts and relationships which went back as far as 1985, the Commission had infringed the principles of legal certainty and the projection of legitimate expectations. The Commission, paragraph 64, top of page 591, retorted that there was no rule establishing a limitation period and that the applicants cannot rely on the principles they invoke, i.e. legal certainty. France, interestingly, at paragraph 65, adopted a hybrid approach, somewhat presciently perhaps, saying that in the absence of a limitation period adopted by the EU, it was preferable to consider on a case-by-case basis whether the principle of legal certainty had been respected. The Court, however, recognised in paragraph 67 no limitation period had been set by the EU legislature. If they were to set a limitation period, they'd have to specify it in advance in order to meet the requirements of legal certainty. They then, at 68 through to 70, rejected the pleas based on legal certainty. First off, in paragraph 68, they refused to apply, by analogy, the period of 5 years that governed delictual liability of the EU. Secondly, they said that it wasn't, save in exceptional circumstances, open to a recipient of state aid to have a legitimate expectation that it wouldn't be recovered. Why? Because otherwise you drive coach horses through state aid laws. Typically, state aid is granted without being notified to the Commission. The Commission therefore doesn't know about it. If there was a legitimate expectation against recovery many years after the event, the Commission would have no sensible way of patrolling, policing the grant of subsidies by member state. And therefore, paragraph 70, on those grounds, and because the existence of exceptional circumstances has not been established, these two pleas must be rejected. So if exceptional circumstances had been established, the trader would be able to show a legitimate expectation that recovery would not take place. But absent that, the absence of the limitation period was determinative. What you don't get from that case is any finding by the CJEU that it's a general principle of legal certainty that you must have limitation periods in place, because otherwise the applicant's plea at paragraph 61 would have been accepted. The next authority to like effect is at tab 10, case involving the Italian Republic, Commission versus Italy. Italy versus the Commission, I should say. That's at page 608 of the electronic. It's where the judgment starts. And in this particular case, paragraph 17, page 614, the Commission had adopted a contested decision, effectively finding a state aid had been granted, infringement of the state aid rules through measures to support road hauliers in the Italian region. Paragraph 81, which is at page 644, the Italian government sought to reformulate a plea to the effect that in particular cases such as this, where the measure has been applied over a very long period without giving rise to any objection and has even been lawful and compatible for a large proportion of that period, it contravened legitimate expectations to permit recovery. Paragraph 82 sets out the core of the Italian government's argument. Please could I invite your lordships and your ladyship to read that. The response from the Commission at paragraph 84 was twofold. Firstly, no limitation period. Secondly, no exceptional circumstances to create a legitimate expectation. The Court broadly upheld that approach. Paragraph 89, for example, it recognised that if a limitation period was to be set, it would have to be fixed in advance, but that hadn't taken place in this case. It was only with the advent of the 1999 regulation that a limitation period was applied, because that was not applicable as a temporal matter in this particular case. And then at 90, the Court said this: however, the fundamental requirement of legal certainty has the effect of preventing the Commission from indefinitely delaying the exercise of its powers. In that regard, a delay by the Commission in deciding that an aid is illegal and must be abolished and recovered by a Member State could, in certain circumstances, establish a legitimate expectation on the part of the recipients of that aid, so as to prevent the Commission from requiring that Member State to order a refund. However, the facts of the case giving rise to that were exceptional, and this isn't an exceptional case. Paragraph 91, in any event, in the case of state aid that has not been notified, such a delay may be imputed to the Commission only from the time when it learned of the existence of the aid incompatible with the common market. So two things. Firstly, the absence of limitation period means there is no limitation period. What is the position that's then applied? Well, you can have legal certainty requiring the Commission to stop sitting on its hands, and that can apply as a shield to an enforcement action by the Commission if you establish a legitimate expectation. Be through that process that you would establish a requirement not to act. But you can't complain about what the Commission has done if, in fact, you never notified the Commission of the problem in the first place. In this particular case, see paragraph 92, because of the complex situation and because of the late notification, the time that the Commission had taken to reach its decision did not infringe the principle of legal certainty in the form of the protection of legitimate expectation. So, what we say those cases establish is that legal certainty doesn't require a limitation period to be put in place. But if you don't have one, then it can come to the aid of a taxpayer by requiring an executive body to act within a reasonable period of time, so that you don't have what the Court described as a delay where the Commission was indefinitely delaying the exercise of its powers. So that is the constraint that the general EU law principle exercises. It doesn't mandate a positive obligation to put in place a limitation period, because otherwise the Court wouldn't have needed to go there. It would have simply said the EU regime is unlawful because there is no limitation period in place. That reasoning has effectively been followed by the Court of Appeal in two cases. First, British Telecoms PLC, it's referred to in our case, I don't propose to turn it up. And secondly, in GMAC and HMRC. In both cases, full references are in our case, the Court of Appeal concluded that the Commissioners could not invoke a concept of a reasonable period of time against the taxpayer that the absence of a limitation period was surprising but not unwarranted. And the only time at which a general principle to act within a reasonable period of time, a duty of promptitude could be exacted against a taxpayer was arguably if there was no domestic mechanism in place by which a particular claim for repayment of tax could be exercised. So, those are cases where the Court of Appeal has expressly recognised that the absence of a limitation period does not stop an ability of a taxpayer to reclaim tax. We say, in this case, source for the goose, source for the gander. The absence of a limitation period can't preclude us taking steps to recover tax, but of course it's subject to the protections that the individual taxpayer will have, either as a matter of legitimate expectations or more generally through avoiding stale claims. Now, our case has recognised, see paragraph 41, electronic bundle, page 79, that this general EU law principle of promptitude, or an obligation to act within a reasonable period, can be invoked in appropriate cases. And we rely on a trilogy of cases to establish that proposition. The first is the Sanders case, which is in the Supplemental Authorities, tab 59, electronic bundle, page 1704. This is in the supplemental volume because the original version in the main bundle was the incorrect judgment. The case involves quite a complicated claim by certain staff members of the EU Atomic Agency, European Euratom Agency, who were treated differently from mainstream civil servants. The underlying facts aren't particularly relevant, but at paragraph 39, page 1720, the essential claim that was made was these particular staff members had been discriminated against compared to other members on different schemes, different employment schemes. The nature of the dispute is summarised at paragraph 41. They submitted essentially there had been discrimination against them and they claimed compensation as a result. So it was a staff claim for damages based on discrimination. At paragraph 49, page 1724, we see that the applicants in question brought themselves within the framework of the staff regulations. Paragraph 58, the court noted it was common ground that the applicants followed the procedure laid down in the staff regulations, and that laid down no time limit for the submission of a request. So they invoked the right procedure. The procedure didn't require them to submit a claim within any particular period of time. The question was whether or not the long period of time that passed between the original events and their subsequent claim precluded them from advancing the claim. The court identified at paragraphs 59 through to 61 an obligation to act within a reasonable period of time in all cases where, in the absence of any statutory rule, the principles of legal certainty or protection of legitimate expectation precluded EU institutions and natural persons from acting without any time limits. Please would the court read 59 through to 61, which set out the court's reasoning on the identification of that principle.
In relation to paragraph 60, you accept, as I understand it, that the obligation which is said there to lie on community institutions would also lie on national institutions when implementing community law.
Yes, or acting within the scope of EU law. What the court then did at paragraph 63 was to apply a like requirement by analogy to a request for a decision by persons who are neither officials nor servants but who approach the institution and ask them to give a review. The duty incumbent on individuals to act within a reasonable time and submitting a claim for compensation was prompted by the need for legal certainty, preventing the imposition on community budget costs arising from one particular event which occurred too long ago. The underlying principle in all these cases is to achieve certainty in the sense of everyone knows where they stand after the passage of time. In this case, the court was recognising that that would apply equally to people making claims which weren't subject to a specific limitation period. Paragraph 66, the court specifically tied in the obligation to act within a reasonable time to the principle of legal certainty. And at 67, question of how reasonable is reasonable was to be determined in the light of all the circumstances of the case. That didn't, it seems, give rise to any concerns about the ability to ascertain that period, because the court would exercise a judicial function and work out what was a reasonable period of time. On the facts of this case, 72, the court applied by analogy a 5-year period for actions in non-contractual liability. So they said that they should have made the request to the EU institution and bring it to an end within a reasonable time, which cannot exceed 5 years from the date they became aware of the situation they complained of. So essentially a broad, reasonable approach was taken to the point of time in which claims had to be made. Based on this. That was then followed in the Allen case. That's at tab 8 of the primary bundle of authorities. I'll get the reference in a moment. Judgment starts at page 556 of the electronic bundle. And given the passage of time on my submissions, if I could turn please to paragraph 26 for the point of principle.
Page.
That is page 559. Please would the court read paragraph 26? You then see at page 564, an argument was deployed at paragraph 55 by reference to the Uniplex case, which concerned the time periods for judicial review in this country and the possibility of a time period shorter than 3 months being applied. Paragraph 56, the court said, in that regard, it should be noted that the Civil Service Tribunal did not err in law. The relevant legal context in the present case is different from that in Uniplex. In the latter case, the time limit issue was one set by the legislature, which could be reduced by the judicature, whereas in the present case, no time limit has been set by the legislature, and hence it is for the judicature to decide on it and according to the principle of legal certainty. So the court had no issue with the judiciary identifying the reasonable period within which a claim could be brought. The third case is the case of Nencini, which the court will find on tab 12 of the primary authorities bundle, page 723. 723.
Thank you.
My lady, the facts of that case were that an MEP had overclaimed expenses for a period of 5 years from 1994 to 1999. We've seen at page 724. Parliament adopted a procedure to verify the expenses. It took essentially up to 6 years because it was December 2006 before they reported, and then it was only in 2010 that the Secretary-General of the Parliament adopted a decision appointing a recovery procedure. Complicated procedural meant that there were 2 separate recovery procedures, but that isn't the key point. The key point here is that there was a significant period of time before the adoption of the decision requiring a recovery and the events which had in fact taken place. The relevant provisions, in fact, contained a time limit. See paragraph 36, page 727. It So there was in fact a time limit of 5 years in this case, but only applied once you'd been notified of the debt that was due. So of course there was no primary limit on circumstances giving rise to the debt. It was only when the relevant officer of the European Parliament notified the debt that time started to run. And what that meant, of course, was that you could have a very large period of time before you got around to notifying the debt. Paragraph 38 to 39, the court identified and recapitulated the reasonable time principle.
Well, I think there it's simply narrating what the General Court had said.
Found, yes. So the General Court had identified that. 41 and 42, the General Court had identified an infringement of that principle. Nonetheless, the General Court had said, well, it wouldn't have made any difference because it hasn't affected the ability of the MEP in question to defend his rights. This case actually turns on that sort of no significant breach point rather than the underlying point. Could I please invite you to read 45 through to 50, which contains the court's reasoning as to why that procedure infringed the reasonable time principle. So that's 45 through to 50, page 729. Accordingly, the answer from the court was not, oh, well, you have to put in place a limitation period that works. The answer was, we will invoke the principle of legal certainty as a defence to any executive act that you, Parliament, then bring against this individual. And that was also the way that the Advocate General Spooner dealt with the issue, starting at page 737 of the electronic bundle, paragraph 78 of the AG's opinion. Paragraph 78, the Advocate General said he remained convinced that the European Union courts must assume in full their role in order to condemn breaches of the principle of legal certainty in the individual cases brought before them. That said, I do not think that that role can legitimately go so far as to establish a new limitation period. In my opinion, establishment of the limitation period is a matter for the legislature. It then sets out a host of reasons through to paragraph 90 as to why it was for the legislature, not the judicature, to establish a limitation period. That didn't mean that courts were powerless and that debts could be enforced ad infinitum. It simply meant that you invoked a different principle, namely the principle of legal certainty, to prevent the exercise of that ability to charge for a debt once the reasonable time for doing so had expired. And so at paragraph 94, at page 738, we see, in such circumstances which give rise to legal uncertainty, the European Union courts must, in my opinion, have recourse to any instrument within their powers in order to ensure full compliance with the principle of legal certainty in proceedings before them. And that gave rise, in paragraph 99, to the application of the reasonable period principle. Whilst that didn't carry the same degree of legal certainty and foreseeability as a prescribed limitation period, it was appropriate as a response to what would otherwise be the potential for stale debts to be enforced against MEPs. So the solution of the court, and indeed the Advocate General, was to recognise they can't impose a limitation period, but to provide protection through the general principle of EU law that was invoked. Now, there are two authorities that are cited against me in this case. And given, again, the passage of time, I'm not proposing to deploy my retaliation in advance.
Can I just ask, I don't know if you've given consideration to this, but we can see here how the court looked at the time limit applicable in limitation period applicable in ordinary circumstances and took that as a starting point. Article 2213 applies in the ordinary case, and well, there's been no dishonesty or misleading of the authorities, and there they have 3 years from the date on which the customs debt was incurred. So in the ordinary situation, that would be effectively gives them 3 years from the date on which they're in a position to calculate the amount due. I wonder if anyone's thought about the possibility of applying that by analogy to a situation where awareness of the awareness with reasonable diligence to be aware of the amount due doesn't occur until a later point in time, and saying, well, once you could, with reasonable diligence, be aware of the amount, then your 3-year period should start running then.
Factual analysis hasn't taken place. That would certainly be one possible implementation.
I'm sort of thinking about it as being a way of approaching what would be a reasonable period on your approach, deriving it from the customs code itself, rather than purely national sources.
On the facts here, of course, that would mean we were out of time. But as a matter of principle, I accept that one approach the FTT could have taken, if it was going down the route of saying, well, there is no limitation period, what is a reasonable period of time for legal certainty purposes? They could have applied, arguably by analogy, a 3-year limitation period from a date of knowledge. That wasn't, in fact, the way that the FTT went, because the challenge was very much a systemic one. There is no limitation period, and that's an end to it.
Yeah.
There was no effort made to establish on the individual facts of the case what a reasonable response would be, either from the taxpayer or indeed from the revenue. If that process were to be done now, in my respectful submission, it might well require the FTT further findings of fact. Yes, I accept in principle that could be one way of skinning the particular cat. Now, there are two cases against me. I don't think I have time to open them fully. Can I simply tell you what my response is? It's already set out in our case in any event. Velo Service was the case which dealt with the ability of customs authorities to amend a customs declaration. And it's sufficient for me simply to turn up one particular paragraph. So the court, in essence, said, well, of course, you've got a 3-year limitation period that extinguishes a customs debt, therefore there's no point having power to amend a customs declaration once that period has passed. And it applied therefore 2213 by example. Velo Service is at tab 14 of the Primary Authorities, page 761. If I could simply turn to paragraph 37, acknowledging, of course, that there is a reference in paragraph 31 to the fact that taxpayers shouldn't have their rights or obligations open to challenge indefinitely. At 37, the court nonetheless noted, see, this is at page 767, it must moreover be possible to take such a measure, that's examining the declaration, even after expiry of that 3-year period, in a situation where the customs debt is the result within the meaning of 2214 of an act which on the date it's committed could give rise to criminal court proceedings, which it is for the referring court to verify. So whilst the 3-year limitation period applied by analogy to the exercise of the power under Article 78 to verify the declaration of amendment, nonetheless the court recognised that where it was a criminal act, you didn't have that 3-year limitation period, you were able effectively to examine the measure after the expiry of that period. The court didn't say, and there must be a limitation period imposed as part of that exercise. They simply recognised it was open to a member state to do so. The second case is the Zayfu Fleischhandel case.
Sorry, just on paragraph 37, there was no provision saying that national authorities, national governments could impose whatever time limit they thought appropriate.
Wasn't dealt with because
It is filling a gap in 37.
it cross-referred to 2214,
Yes.
recognising that the 3-year limitation period wouldn't apply where those criteria were met.
Yes.
So it's simply recognising the overall structure of 2213 and 2214.
So it goes no further than that.
It goes no further than that. But the point it's making is, therefore, the 3-year limitation period doesn't apply in those circumstances. They didn't say, oh, and by the way, that is a breach of a principle we've identified at paragraph 31. So, in a sense, it's what it doesn't say rather than what it does say, because it's not authority, we say, for the proposition that there's a requirement to impose a limitation period. Otherwise, the court said so at that stage. And the second case is the Fleischhandel case behind tab 15, page 769. This particular case related to a beef export refund claim. Beef had gone to Jordan and then, I think, been shipped to Iraq, which meant that it hadn't been declared for free circulation in Jordan, which meant that the refunds weren't payable. But none of this came to light until several years later. The relevant part of the decision that is relied upon against me is, in a nutshell, paragraph 52, page 790. Amongst others. And the court, on one view, can be taken to saying, well, if you don't have a limitation period in the legal system, that runs counter to the principle of legal certainty. So, A, you have to put in place a limitation period, and B, that must be fixed in advance. And that's certainly how the Court of Appeal read it. My response to that is essentially twofold. Firstly, the particular regime that we're looking at is Article 3.3 of the regulation I took your lordships and your ladyship to, which is the requirement to put in place a limitation period if you don't, in fact, want the 4-year default provision. So that's the first point. This case only arises in this way because, of course, the 4-year period is the default position unless a member state retains different domestic legislation, which is a defined limitation period. And so the court at paragraph 52 is saying if you don't want 4 years, you've got to put something in place. And in order to comply with legal certainty, that limitation period has to be fixed in advance. Paragraph 30, however, the court did recognise that it was open to a member state to apply its established practice, judicial practice, in order to give effect to a limitation period.
Paragraph, sorry?
I thought it was 30 at page 783.
30, thank you.
That's dealing with the application of a prescription period by analogy.
Yes. And in that particular case, it was the 30-year rule under German civil code, which was being applied by analogy. 32. The court did indeed recognise that it was an aspect of legal certainty that the position of an operator, having regard both to his rights and obligations, could not be challenged indefinitely. It then said, consequently, a limitation period must be applicable to proceedings in respect of such an irregularity. Well, that was necessarily predicated on the fact that you had the 4-year period. And if you didn't have a 4-year period, you didn't have any, so either 4 years or something that you've got under domestic law. But the issue for the court was, can you apply a judicial practice by analogy of a 30-year period? In that regard, paragraph 33, the court said, yes, you can. And in fact, the setting of a 30-year period would not, in fact, infringe the principle of legal certainty as such, because it was known, as long as it was a sufficiently established judicial practice, that wouldn't infringe the principle of legal certainty. Dealt with differently, of course, under the principle of proportionality, because the court failed to understand why you would need 30 years if, in fact, the legislature itself was saying 5 years is enough. I may need to come back to that in reply, because I'm afraid I've dealt with that rather quickly, as I've got to sit down in 15 minutes' time or so.
But do I understand your essential point to be that there, the trigger for the displacement of the default period was the provision of another period, whereas here you presumably say the trigger is the existence of criminal or potentially
Criminal act
conduct.
disapplies.
That's what displaces the period, so it's not pari-material. Yes.
And 2214 doesn't actually set a limitation period. That's the case that I went through earlier. Default to the competence of the member state. The member state chooses what limitations period to put in place. No obligation to set a limitation period. Most that can be said is that if we sat on our hands for too long, then a trader can invoke a general principle of EU law to prevent that exercise of executive power.
Might that also explain why Article 217 of the Code refers to expiration of the time allowed for bringing a claim, not the expiration of a period or date?
217, my lady, of the Customs Code itself.
Yes. It's a small point. You could come back to it. Don't worry about taking time now. It's discounting amounts of duty which under 2213 could not be communicated until after the end of the time allowed. It would be consistent with what you're saying.
Yes, thank you. Grounds 3 and 4 have been dealt with at some length in our case, and I think I can, unless you'd like me to, take them relatively lightly. Ground 3 is addressed at paragraph 69 and 70 of our case. So, in essence, we say there must be a procedure by which the first-tier tribunal could, in an appropriate case, rule that the matter was too stale to be heard by it. And so, in a sense, ground 2 deals with what are the constraints on the customs authorities as executive bodies, i.e. stopping behaving in a certain way. But in practical terms, it will be before a court or tribunal, assuming that the customs authority persists in seeking to claim the customs debt. It will be a court or tribunal that is then the forum for the exercise of this weighing process of how stale is the claim and is it unfair to proceed with it. We say the ordinary rules of procedure available to the FTT would prevent procedural unfairness or abuse of process. You can get there also through Article 6 considerations, which Article 6 doesn't directly apply, but Article 47 of the Charter gives effect to Article 6 time conditions, requirement for a hearing to be in a reasonable period of time. True it is that it would be a hearing before the tribunal, but of course the hearing before the tribunal would be the vindication of the EU law rights. And so if the process is so stale that a taxpayer can't sensibly achieve practical justice, then Article 47 could be invoked as a reason why, for reasons of legal certainty, the claim should not go ahead. That derives some support from, for example, the Group Gascon case in the CJEU, which is tab 47, Electronic Bundle 1394. That's dealing specifically with length of time for competition cases and before the General Court. The court recognised that if matters had gone on for so long, that was a ground for intervention. Not entirely analogous, but we do say that if a claim has been sat on by the commissioners so that the actual hearing before the tribunal is many years hence, then that can be a ground for intervention. You've got the common law powers to deal with abuse of process and want of prosecution, which are very familiar to this court. And then finally, you have the doctrine of laches in the Lindsay Petroleum case in its classic formulation, where delay can be a bar to relief on equitable grounds, in particular in that case where there was an allegation of a right to recover through fraud. Now, I accept that none of these domestic procedures is an ideal fit. But what they do, in my respectful submission, is they enable the principle of legal certainty to take effect through the prism of domestic law. And Lord Sumption, in the FII case in this court, paragraph 147, that's Electronic Bundle, page 925, made the clear point that what you do is you mould the domestic procedures available so as to give effect to the EU law right. And he went so far as to say, actually, you might have to invent a domestic procedure to give effect to it. We say you don't need to go that far in this case because it would be open to the FTT simply to look at composite powers under common law, charter, and possibly under the equitable regulations to prevent stale claims going ahead. And therefore, with respect, Mr. Justice Burst was quite right in the Upper Tribunal, paragraph 34, electronic bundle, page 164, where he said, the common law and rules of equity already equip the courts to prevent procedural unfairness in proper cases. And therefore, striking a claim as abusive as a result of an delay, which would make a fair trial impossible. And that, in essence, is what the complaint is here. The complaint is not, well, you, the UK as a member state, have wrongly failed systemically to put in place a limitation period. This taxpayer cares about facing a claim which is said to be a claim that arises too long after the events in question. The way to achieve that practical result for that taxpayer would be to ensure that these protections are available to it. If I'm wrong on that, and if there is somehow a positive obligation imposed by an EU general principle to put in place a limitation period, then my fourth ground, at paragraph 71 to 73 of our case, says that it's appropriate to adopt a structural response, which is Marleasing response, and to deal with the incompatibility. That incompatibility would arise in practice from the application of section 37(2)(a) of the Limitation Act. If that particular exception for charges to customs duty, amongst others, was struck through for this particular trader, then you would have in place a legal regime under the Limitation Act which could be applied to protect the trader from stale claims through the application of the Limitation Act. And that's a process which has been used in a variety of cases. We've cited Repertoire Culinaire, the Liberty case, standard approach now, highly muscular statutory construction under Marleasing, put a red line through that particular provision and you end up with a system that works.
Perhaps a difficulty with that submission is the premise on which it starts, namely if there is a positive obligation to put in place a limitation period. If there is that obligation, then the absence of the limitation period provides the taxpayer with the protection. And striking out section 37(2)(a), in fact, is freeing up the revenue rather than protecting the taxpayer.
I see the force of that point, my Lord, of course, but what one has to consider is what is the right that is at play. And in essence, what is happening here is Parliament has said in section 37(2)(a) there is no limitation period. If Parliament is wrong to have done so, then you would construe parliamentary intention as being to ensure that that breach of EU law under the European Union Act is remedied through the Marleasing approach, which is taken to be what Parliament has sanctioned through maintaining the supremacy of EU law, and that therefore Parliament would have intended any lacuna in its legislative regime to be remedied through the Marleasing approach. And that indeed is reasonably foreseeable and sufficiently ascertainable because it's been happening since Factor Table in 1989.
Thank you.
There's then a mild diversion into whether or not there would be fraud for the purposes of Section 32 established. I think at this stage of my submissions, I would acknowledge that further findings would need to be made on that. But it's certainly open in principle to the commissioners to be able to show fraud on the part of an agent, i.e. the exporter, giving rise to an entitlement to treat a date of knowledge.
I mean, what we were saying wouldn't be an application of Marleasing. It wouldn't be interpretation of legislation. You would be disapplying a provision. So it's a factor tame, if you like.
So that's the point that's often made in the case law, that whilst it's treated as a principle of statutory construction, in practice it ends up becoming a disapplication, which only in the very loosest sense can be described as a process of statutory construction.
Yeah.
What it amounts to is a recognition that Parliament, through the European Communities Act, has said to the courts, you can do this. And that's been recognised since certainly 1989.
I mean, Marleasing is actually a lot narrower than people tend to think it is. If you look at how, I won't get into it just now, but I'm a bit sceptical of an expansive interpretation of Marleasing.
I respectfully agree. I mean, the times where it has been relied upon, in Repertoire Culinaire, for example, the court recognised that the core elements of the UK's implementation was valid, and it struck down the conditions which
were invalid in place of valid scheme. The Court of Appeal in IDT, where the government gave the judgment, recognised that you could read words into the relevant provisions of the VAT Act to cure what would otherwise be a deficiency under EU law. And in
Liberty, Lord Justice Singh recognised that it could, in principle, be open to the court to disapply, but because you would end up needing some sort of working legislative scheme, he was reluctant to do so and confined himself to a declaration. So there are different ways of doing it, depending on what the context involves. Here we do say, if the concern is you've got no limitation regime, and if Parliament intends that EU law breach to be cured, the easiest way to do it is to strike a line through 37.2a. Now, we do obviously pray and aid the fact that the outcome of this case, if the Court of Appeal's reasoning is upheld, is that many frauds which haven't been detected at the date within 3 years of the customs declarations will, under our domestic regime, not be capable of being effectively policed. You'll have seen in our case we've referred to the MAS decision. That's in tab 40 of additional authorities, page 1173. It's an unusual case in many ways because the CJEU said you have to disapply limitation periods that have been too unduly lenient to fraudsters in the criminal code in Italy. You have to actually disapply those limitation periods to ensure the effective enforcement of customs duties and to prevent fraud. It's a very extreme case. It shows quite how far the obligation to counter fraud and to get customs duty in can go. What we say is the EU case law makes clear that the burden of fraud should fall on those who contract with fraudsters and not on the general budget of the EU, which pays for a whole host of programs. We have to account for own resources. If we aren't able to account for own resources, we face the risk of infraction proceedings. So that doesn't mean, of course, that you can ride roughshod over individuals' rights. That isn't what we're seeking to do here. We're recognising that in a given case, an individual can properly raise before the tribunal that a case is stale or that he or she does not have access to justice because a fair hearing is no longer possible. That individual can also say you, the UK, through the commissioners, have failed to act within a reasonable period of time and therefore you are precluded from raising these further charges against us. And of course, if that's the case, it's our fault and there any statutory burden is resolved. In this case, there has been no suggestion that the procedure was unfair. You will have seen from the FTT's decision at the first instance that all of the evidence was gone through again. There was no real objection from FMX through their counsel at the time that challenged any of the underlying factual material, and nor was any suggestion made that the claim was too stale to be heard. The reality was there had been a full hearing of the first batch of cases, and then once findings were made by the first tier tribunal in FMX1 that there was no waiver or remittal of those duties, the same duties were then charged for the earlier period based on the fact that a criminal act had been established as a result of the FTT1 procedure. So that is what has happened. If I'm wrong on that, and there is somehow a claim residually to this being an unfair procedure, then the appropriate course would be to remit to the first tier for further findings to be made in the light of the legal analysis that your worship and your lordship see fit to adopt. Would the court please give me a moment? My junior has been diligent next to me while I've been making this submission. He's found the Covita reference. It's case C370/96. COVITA is the name of the case. The ECLI reference is EUC 1998-567, and I'm told that paragraph 36 deals with the predecessor of the Customs Code in 1989, and it covers the point. Fine.
Thank you very much.
Unless I can be of any further assistance, those are my submissions.
Yeah. Mr. Pritchard, do you wish to offer us any further assistance? Mr. Cavender.
My Lord, my Lady, as we've seen, this is a case which involves a member state seeking to recover European customs duty pursuant to the terms of an EU directive, customs code. It's worth bearing that point in mind throughout. It is a European levy being recovered pursuant to a European directive to which certain legal consequences flow under European law. The position of the revenue in my submission is quite an extreme one, looked through that prism of European law and a European levy, is that there is no time limit whatever applicable to the recovery of this customs duty, subject only to a duty to recover it within a reasonable time, whatever that means. And standing here now, I still don't know what the revenues case really is on reasonable time or how to calculate it. I can infer from the written case what it might be, but it is an oddity and perhaps illustrative that they've not embarked at any stage on articulating what a reasonable time is or how one would begin to calculate it. It was a point, of course, only raised in the Court of Appeal for the first time by way of legal argument, effectively. So that's where we are. On the other side, we say there is a fixed period of limitation of 3 years, as set out in Article 2213. The UK has failed to exercise the power it undoubtedly had to enact an extended limitation period, and that therefore the primary period of limitation of 3 years applies. So in broad outline, that's where we are. There are, of course, 4 grounds of appeal. The first 2 deal with the construction of 2214 and the legal principles applicable, and the third ground of appeal we've just heard about stale claims, and then the 4th dealing with misapplication. Can I deal with ground 1 and ground 2 really together and articulate 3 questions which, in my submission, encapsulate the position under grounds 1 and 2 in really 3 questions. Question 1 is Article 2214 to be taken to disapply the primary limitation period provided for in Article 2213 in all cases that fall within the factual scope of the article, or only those where a member state has enacted in national law conditions that provide for an extended limitation period? So that's question 1. Question 2 is, if the answer to the question 1 is in all cases, is it compatible with EU law for a member state to seek recovery of an EU levy without limit in time, or would such provision be contrary to legal certainty? And question 3 is any lack of legal certainty contemplated by question 2 sufficiently dealt with by the principle, if there is one, of acting within a reasonable time, as seen in the line of cases involving EU institutions such as Nensini? I say if there is one, because of course those cases were involving EU institutions, institutions, and of course we then had the state aid cases, but I'll come to that. But by way of introduction, if I may, a few words on the importance of time limits generally. In my submission, any coherent developed system of law can be expected to attach specific time limits, after which HMRC would not be entitled to make demands for such duties. The reason, of course, is obvious: finality. Businesses cannot be exposed indefinitely to the possibility of such demands, running to millions of pounds, very many years after the relevant export. Here, the time limit, and I'll go to it in a moment, it's all over 7 years. The earliest is 7 years, 1 month, and the going up to 7 years, 6 months. So after communication. So that's the period of time we're talking about. And also it's all a short period over 4 years from the period when the revenue knew of the relevant facts. So of course we're dealing here at a much higher level of abstraction about the general principle, but those are the facts in this particular case. There are, I understand it, cases in the First Tier Tribunal at the moment ongoing where some 10 years after the relevant events, with no fault at all of the relevant importer, these claims are being brought.
So on the facts of this case, if, for example, to consider the last possibility that Mr. Beale raised, one were to say that the 1980 Act, Section 37(1), is simply incompatible with EU law and must be disapplied, the consequence would be that these claims would not be time-barred because they were made within 6 years of the time when the revenue were aware of relevant facts.
But to put it another way, my lord, for my friend to win in this case, he would have to apply both a 6-year limitation period and delay the postponement. He would need both elements. I think that answers your lordship's question. So we say, as a matter of principle, as a matter of general European law, that the idea you would have the recovery of an EU duty like this without a limitation period is an anathema to EU law. A member state acting against a citizen in relation to tax without limiting time is a very surprising and shocking proposition.
I wondered if you were aware that the Law Commission accepted that there was good reason from the point of view of tax management that this section 37(2)(a) 1A should apply and continue to apply, notwithstanding its recommendation for a very altered regime.
But your lady,
In a final report.
it was for it to be maintained, because as you know,
Yes.
there is, in all areas of tax, direct and indirect, specific time limits, which is why 37A is there,
But there were specific reasons in relation to customs put forward, which are developed in the report.
in order to maintain it, my lady. Yes. No, I'm obliged for that. But that's the way the tax system works, is that they have specific time limits for everything. That's why 37(2)(a) is there. It's not an oversight. It is a deliberate mechanism to allow tax to be dealt with differently. So it's out of step generally with limitation in EU law. It's also out of step with limitation rules in the UK. So in relation to tax matters generally, and we put this in our written case, there's a 20-year long stop, even where there's deliberate evasion of tax. See para 7 of our written case. And footnote 3, we outline all the various periods available to various taxes. So VAT is generally 4 years, 6 years if there's carelessness, corporation tax 6 years, but all subject to a 20-year long stop, and that's set out in specific provisions. We then have, of course, a Limitation Act, and I don't think I need to go through that. Here, of course, the criminal element relied upon to come within 2214 is Section 167 of the Taxes Management Act, and as we'll go to in a moment, that doesn't require anything other than a defect in the return. It doesn't require any mens rea, a lack of care at all, and that's important. My learned friend puts this case forward, when he does turn the jury light on from time to time, as a construction almost, advanced to protect against fraud. And therefore a construction or an approach should be taken consonant with that objective. But here there are a number of powers HMRC have to act against fraudsters. Obviously criminal prosecution, Section 25 of the Finance Act, for a period up to 20 years, you can seek the imposition of a penalty equal to the amount of the unpaid duty. The only proviso to that is you have to bring it within 2 years of coming in notice of the relevant facts. So there's no reason as a matter of policy in my submission to give these provisions anything other than their unvarnished approach. The other thing about the facts of this case as well is that the word fraud is used from time to time, but my client has not been held guilty of fraud at all. If you go to FMX 1, which is in core volume starting at page 179, we see at paragraph 51 of that decision, so it's electronic page 191, that good faith within the code has a special meaning. And we'll see from paragraph 51, electronic page 191, that it means having not exercised due diligence or due care. And it's that, if we go to electronic page 194, para 67, the last sentence, the finding of the first tier tribunal was FMX did not exercise all reasonable care. So the word fraud, etc., needs to be handled carefully, both generally and in relation to this particular matter. In terms of paragraph 1673, can we go to authorities primary tab 1409, just have a quick look at that provision, because that's the anchor for the criminal provisions reliance. So that's Electronic Bundle 409, primary authorities. (1673), page 409. If any person makes, signs, causes to be signed, or delivers, causes to be delivered, any document untrue in any material particular, So it is an actus reus. There's no mental element whatever within that requirement. Is a strict liability. And of course, under the law, traders have to keep their records for 4 years, maintain them. But under my learned friend's approach, the revenues approach here, a trader could in fact find a demand 10, 20 years after the relevant import, based on the behaviour of an importer about which it doesn't know, where it can't, 10 or 20 years hence, or 10, prove the details it needs to prove, because papers have gone, people have gone. And so that is a significant burden on a trader, and of course a significant inroad into the principle of uncertainty. So that is time limits. The general principles of EU law are applicable to construction. My learned friend's right, there's no real debate about that. They have to be considered with regard to their wording, context and objectives. It says that in Firma East, para 22, additional authority to tab 45, page 1373. Learned friend refers to Zentral, which is para 44, core, page 80, which talks about including the context in which they occur and the purpose of rules of which they form part. There's no dispute about any of that. But the aims of EU law do not require or justify indefinite rights of duty collection, even to tackle deliberate fraud. Why do I say that? Well, look at the new UCC code, which has a 10-year long stop, even in the case of deliberate fraud by the actual trader. And you'll find the UCC code at Additional Authority 1, tab 26, page 844 at 845. We will see also in a moment on the same point in Zuflischhandel, where you have in the regulation there the same objective of protecting the EU coffers as a purpose, protecting fraud, protecting their coffers. But even then, that requirement does not trump the central requirement of legal certainty. I also, in my submission, say that the Article 2214 and 3 must be interpreted in a manner that is contrary to comply with the principles of EU law, particularly certainty, not construed in such a way as to produce uncertainty, which is, in my submission, what my learned friend's submission amounts to. Now, the starting point in this is the decision of this court in FII, the case that occupied some time in this court, and there were references.
Hasn't stopped yet.
No, my lord, no.
It comes back to us next term.
Well, my lord was in it, obviously, as was I. Earlier stages, I was. But can I take you to it, if I dare? Additional Authorities 1, tab 29. And it's really for the citation from Lord Sumption's judgment.
Page?
It's at page 926, about the importance of legal certainty.
Lord Sumption was in a minority on some issues, but I can't recollect whether he was in a minority on this question.
My lord, no, he's quite right. He's in the minority on the 320 question. Yeah. The court was unanimous on the 107 question. But this is a general point of principle, so I don't think it matters for these purposes. So I don't think I need to go through the facts of the case. It was involving limitation periods and the removal of an extended limitation period for mistake of law under Kleinwort-Benson. It was removed retrospectively in part. And the question is, was that within or without European law? And it's really paragraph 146, if your lordship could read that to yourself, starting with the reference there to Rue 1.
It's really the third principle
The third
that you're
principle.
concerned with. It's the bottom half of the paragraph.
My lord's quite right, it's from G to H, exactly.
There is a third principle.
Indeed, I'm obliged.
I mean, that's not, as I see it, can't be seriously an issue that there is that third principle. The question we have is, what are those consequences in the present case?
Lord, that's certainly right.
Nothing in Mr. Beale's submissions challenges that there is that third principle.
But, my lord, no, it's really I suppose, the impact of it.
Yeah.
Yeah.
And we don't get much about the impact just from this passage.
My lord, not just that passage. If we then go to paragraph 149.
149.
So page 927. Not only is a limitation a feature of every national system of the EU, but the recognition of national rules of limitation as both necessary and desirable is treated as part of the principle of legal certainty in EU law. And he cites there in Rule 1, says, in the laying down of such time limits with regard to actions of a fiscal nature is the application of the fundamental principle of legal certainty, protecting both the taxpayer and administration concerned. My Lord Reed, just for your own, page 965 is your judgment where you deal with this. And you understandably cite at 965 going to 966, the Marks and Spencer, saying that the principle is part of the principle of legitimate expectations. As a general principle of EU law, this principle binds member states when implementing EU law at national level, and particularly applies to national rules governing the protection of EU rights in national courts, illustrated by Marks and Spencer.
Yeah.
And then in the European Court, this obviously went to the European Court after this, that's Additional Authority 2, page 1348, it's at tab 44. It's really para 33, so that's page 1353. Para 33, the court says, as regards the latter principle, the court has held it compatible with EU law to lay down reasonable time limits for bringing actions in the interest of legal certainty, protects both the taxpayer and the authorities concerned. Such time limits are not liable to render impossible in practice or excessively difficult the exercise of rights. However, in order to serve their purposes of ensuring legal certainty, limitation periods must be fixed in advance. And then over the page para 44, page 1354, to recall that according to settled case law, the principle of legal certainty, the corollary of which is the principle of protection of expectations, requires that rules involving negative consequences for individuals should be clear and precise. Their application should be predictable for those subject to them. As has been observed in para 33, limitation periods must be fixed in advance, so as to serve their purpose of ensuring legal certainty. So my Lord, in answer to my Lord Briggs's point, that FII in this court sets the general principles down, but I think the FII European Court in this passage does go further and indicate both the basis and the context in which that principle applies, and emphasises the importance of time limits more generally, that they are certain, they're fixed in advance, and they provide protection for the taxpayer.
It also, I mean, this effectively tells us that the ordinary 6-year period is a reasonable period from the point of view of EU law.
Yes. So what I say you get out of the FII, both in the Supreme Court and in the European Court, is that when you are, as a member state, seeking to use EU power to challenge a taxable person seeking an EU duty, you cannot do so indefinitely. You must fix a period, and that must be fixed in advance so it's predictable and foreseeable for the taxpayer. And those are the principles which, after lunch, I'm going to say you should have regard to when we come to the construction of the meaning of Article 2213 and 4.
The whole point in FII, of course, is that it's a 32(1)(c) limitation period that's being relied on. So I presume this must have approved the reasonableness of that period for the purposes of EU law.
It certainly wasn't challenged, I think. Yeah. It's quite interesting. The Court of Appeal note here, based on the Agra decision, which had a similar ratchet, there's more recent authority, certainly from an AG, suggesting that may not be in accordance with EU law because it gives the member state in this situation carte blanche, effectively, as to when the commencement of the limitation period is. Which is why the Court of Appeal in this case raised a little flag saying, well, that may not be lawful, though, of course, that's what happened in Agra. So, my lords, I was going to finish there for lunch, if that's convenient.
Yes, certainly. Thank you. We look forward to hearing you at 2 o'clock.